Good afternoon, everybody. I am Babu, an advocate practicing at High Court for the state of Telangana at Hyderabad. By the previous video, we have completed our discussions up to Article 237. Before taking up discussions on 238 and forward, I would like to discuss a very important topic today, which is concerning the whole nation, that is corruption at high places. In fact, not in high places alone, corruption is everywhere in India from top to bottom. But we are concerned now with corruption at high places, in the sense ministers, high bureaucrats, etc. We are seeing of late state chief ministers are complaining that the center is using ED, income tax and CBI against them to mollify their political careers. Under the false feeling of federalism, they are claiming that the union shall not interfere with their affairs. But in my opinion, it is not fair to argue that even in the corruption of states also, union should not interfere. But in fact, it is coming only to that, because the era of coalition governments have come to stay. The whole polity of India has been divided into two sections, NDA and INDI or the UPA. National parties have lost their charm and they are not able to muster majority on their own. They are necessarily depending on the small parties or the regional parties to form governments at the union level. In states, as a result, even if the regional government resorts to rampant corruption, the union government is not in a position to question it. Not only its alliance partners, it cannot question even any other regional party, because we don't know when which party goes out and when which party comes into the coalition. It has become a game of musical chairs. The anti-defection law of 1985 has complicated this question much more. Instead of anybody defecting from one party to the other party, the anti-defection law brought through 52nd Amendment of 1985 stipulates that if one-third of a political party defects to other political party, the members do not get disqualification. So it has become an encouragement to go in groups instead of as individuals. So the union governments have become incapacitated to question the activities of the regional parties. One political party is accusing the other political party and its members of resorting to corruption, and we are also seeing chief ministers are imprisoning ex-chief ministers. They are getting parliament members and assembly members beaten up, and the union government cannot do anything in this regard except foisting some more cases on the state governments and make a compromise or punish them. This all is happening only because of a misunderstanding of the Indian Constitution that we are going to discuss today. Now the moot question is whether the permission of the governor of that state is required to register a case of corruption against the current or ex chief minister or ministers or MLAs and MPs. Whoever is charged with corruption, sometimes invoking the provisions of Section 17A of Prevention of Corruption Act 1988 and demanding that the permission of the governor is necessary for such prosecution. Let us consider what is contained in Prevention of Corruption Act 1988, Section 17A. Before going to Section 17A, let us first consider whoever come under the purview of this act. This is a central act administered by the state governments. This applies to public servants. Now the question is, who is a public servant? Honorable Supreme Court, in case of Karunanidhi versus Union of India, Honorable Supreme Court decided that the ministers are public servant. This is a case of 1979. But by that time, Prevention of Corruption Act was not enacted. The decision was given under Section 21 of Indian Penal Code. Every person who is paid by the government for any service by way of commission, fees, is also a public servant. employee of any state corporation, a government company, and persons in charge of any cooperative societies which are funded by the state government also come under this definition. If you see this definition, nowhere it is specifically stated that state and central ministers also come under this definition. Section 2C of Prevention of Corruption Act 1988, you find similar definition. Whoever on the pay of the government as fees or commission, and all government officers, officers of the corporations and government companies, the judges, everybody come under the definition of public servant. But in my opinion, ministers are not public servants. Of late, the claim of the politicians charged with corruption have been making a demand invoking Section 17A of Prevention of Corruption Act. Whose permission they are demanding? It is the permission of the governor of that state. Again, we are under wrong impression that a governor is bound by the advices of the Council of Ministers. This is a lopsided understanding of the Constitution. In a democracy, there should be legislative and executive and judiciary separately. If you say that executive is bound by the advice of the Council of Ministers who have majority in the legislatures, you are making executive subordinate to the legislative. As such, there would not be separation of powers and you will not have an executive, effective executive. So, Indian democracy is limping on one leg. But in my opinion, it is not democracy at all. Unless there is separation of powers, it is no democracy at all. If everything is in one person's or one party's hand, who can make law and also implement it, he will become a tyrant, a dictator. He will oppress the opposition parties, resorts to rampant corruption. Now you please tell me, is it very difficult to obtain sanction of the governor to prosecute an opposition ex-chief minister or ex-minister? The party in power will advise the governor to give permission. It is an insult to language to say that all powers are yours, but you should act according to my advice. How an advice can ever become an order or command, especially by the subordinates to their superiors? On one hand, you are saying it needs the permission of the governor. On the other hand, you are saying that the chief minister will advise the governor to give permission. So, is it the permission of the chief minister or the governor? In my childhood, I have learnt a story of bottle imp. Imp is very powerful, but it would be in the hands of a small kid. It has all the powers, but that would act according to the commands of this baby. If it wants, that again fits into that bottle, or if the baby wants, it will commit suicide. Such is a funny story we are enacting in Indian politics by saying all powers are yours, but you have to act according to my advice. In fact, this is the condition contained in Article 48 of the Pakistan Constitution. In India, such conditions are not there in Article 74. It is only through 42nd Amendment of 1976 it was added that the President is bound by the advice of the Council of Ministers. Most unfortunate to 140 crore people of this country. It is an insult to English. Article 163 says that there shall be Council of Ministers in a state with the Chief Minister as head to aid and advise the governor in exercising his functions. But clause 2 says that, however, the state minister shall not be entitled to advise the governor in such of his functions which require his own discretion. 164 says that the chief minister is appointed by the governor, the other ministers are appointed by the governor on the advice of the chief minister, and their terms of office shall be during the pleasure of the governor. So they are hired and fired by the executive for the purpose of aiding and advising them. They are their advisory bodies of the governor. So whatever a minister does, it attaches to the governor as vicarious liability. But the governor and president are shielded from civil and criminal actions during their tenure, as such from civil and criminal cases. They cannot be summoned to courts. Process to arrest them cannot be issued. This being so, the ministers are not separate from the governor. So, seeking the governor to give permission is a ridiculous thing. When it comes to the opposition parties, the governor will give the permission. Even if he does not give, the ruling party will advise him to give. This is only a funny thing. So as such, ministers are not public servants. They are appointed and removed by the governor as helpers and advisors, and whatever they do, they have to report to the governor under Article 167, and whatever crime and corruption they do in discharging their duties as ministers will attract to the governor, who is exempt from all civil and criminal cases. It is the responsibility of the governor to control the ministers in due course of time. The constitutional fathers have intently considered this issue that the present ruling persons may resort to retribution against the previous ruling parties. They have inserted Article 361 to safeguard the executive. That Article 72 and 161 are also provided under the Constitution for the President and Governors to safeguard his employees, who are called executive in public service. Government employees will be undertaking certain sovereign functions. Sometimes they may have to act secretly, stealthily, and they may even violate the laws. Then people may catch hold of them, beat them up, and hand over to police. Police may register a case and hand over to the produce in the court, and the court may send them to jail. Even then, these government officers are not supposed to reveal their identity or their mission. It is the governor in the states under Article 161, and it is the president at the union level under Article 72 who has to protect them. They have a right to waive or reduce the punishments imposed by the courts. This is for this purpose the executive is given powers under Article 72 and 161. Unfortunately, without understanding this, the power of pardon is being used in favor of hardcore criminals, terrorists, extremists. That is most unfair. That is not the purpose of Article 72 or 161. Thank you. Thank you for watching this video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments. I will be dilating on all the articles of the Constitution, highlighting wherever they were not understood, misunderstood, misused or misapplied.